I now would like to recognize Mr. King for his questions.
Thank you, Madam Chair. I thank all the witnesses for being here to testify, and regret my schedule didn't allow me to hear it all in depth. So I hope I don't duplicate anything that has been raised here before this panel. First, I think I need to make a statement as to if anybody wonders where I stand on this issue. And I've looked at it from a whole number of different perspectives. I just don't think it's arguable whether this is sustainable economically, or whether it will improve our health care, or whether it will avoid eventual rationing, or whether it will reduce research and development. I think those things all we understand, at least I think I do thoroughly, that we're not going to see better health care at a cheaper price. It's more accessible or more available. You'll see different people that have access, perhaps, but it's perhaps a shift within the population, but I don't think it changes anything beyond that. Now, so I've spent my life my working life as a small businessman. I started a construction business out in 1975, and we provided, not on the first day because I didn't have any employees the first day, but over a period of time as we began to accumulate employees, I took on a responsibility to voluntarily provide them health insurance. And when I've watched this debate be shifted here in this country, so that the word health care and health insurance those two words have been conflated into the same meaning in the minds of many people that are advocates of this policy that's before us today. I think that was dishonest. I think it was disingenuous, and I think it was willful, a strategic effort to try to blur the definitions. And I remember our then governor of Iowa, Governor Culver, coming to this Capitol in our delegation meeting and saying 40,000 kids in Iowa don't have health care. And I don't know how many times I had to ask him about what that meant before I could get through to him that health care and health insurance were two different things. I'll make the point that I don't believe an employer has, if they choose to accept a responsibility to provide health insurance for their employees, that's a competitive position in the marketplace, but it's not a moral obligation for the employer. To hire good people and keep good people is the motive. When the federal government decides to impose an employer mandate, then that sets another standard. And in the minds of people now, they think it's an entitlement that goes with a job. And I think that's a mistake. I think it saps some of our vitality. But I wanted to take this down to the constitutional aspect of it, and just noticing that we had a law professor here, Mr. Joss, tonight. That's the part that grates on me the worst. We can talk about policy all day long. I've drawn my conclusions on that, and I've also drawn them on the constitutional side of this. But I just take it down to the individual mandate rather than the employer mandate side of this. And ask this question: if the federal government can constitutionally commandeer a portion of a person's paycheck, or a portion of the revenue of an employer for that matter, if they can commandeer that and assign it to a government-produced or government-approved product, which is premiums for health insurance that is approved by the federal government, then what limitation would there be on the commandeering of that revenue stream beyond health care? Is there a constitutional line here I don't understand, or could it also be for a car, an appliance, buying certain types of health food, or a membership in a health clinic, or perhaps a gymnasium? Where is there a constitutional line beyond that? If the Supreme Court rules in favor and upholds this bill, this act, this law of the land, as Mr. Altmaier referred, I believe, if they do that, what then can the rest of the workers and the employers in America look forward to being commandeered? Where's the line?
Well, again, I only have 5 minutes rather than 5 hours, probably rather less than that. And I would refer you to the excellent opinion on this topic written by Judge Sutton of the 6th District, a very well-known conservative judge who's in fact been prominently mentioned as a Supreme Court potential nominee. And what Judge Sutton said, and what the other federal judges, several federal judges, the majority of the federal judges who have considered this question have said in favor of the constitutionality of the statute, and where I believe the Supreme Court will come down, is that Article 1 of the Constitution, Congress has the authority to regulate commerce. Under earlier decisions, Congress must regulate economic decisions. It cannot regulate non-economic conduct. But what Judge Sutton and what the other federal judges have found is that the healthcare marketplace and the health insurance marketplace are interstate commerce. In fact, it's the largest sector of our economy, and that Congress.
Excuse me, Mr. Jost. If an individual doesn't engage in purchasing health insurance, then they're not engaging in interstate commerce with the purchase of health insurance. And if you expand the argument to utilizing health care services, if an individual is born and dies in a state and doesn't cross a state line and doesn't use medical care of any kind, and that happens, it's always happened to every generation, how is it that they're engaging de facto in interstate commerce?
Well, what Judge Sutton said is, on its face, the statute is constitutional. As applied, there may be some situation where somebody will come forward who says, I have never used health care in my life, I will never use health care in my life, I can prove it, the law should not apply to me, and he said that might be a different case. We'll cross that bridge when we come to it.
I think we have come to it, actually. I think we have come to it because the Constitution's got to apply to everybody.
Right, but a statute, the first question is, has Congress written a statute that is facially constitutional? Could it be constitutional as applied to some people? And as applied to 99.99999% of the population, people use health care.
Let me say that the statute presumes that everyone does use health care, and it presumes that health insurance is an obligation that's a component of health care. And if it presumes that everyone is utilizing, then the constitutional rights of those who do not are directly then incorporated into that. So they don't have their constitutional rights unless they assert them. We have to pass legislation that constitutionally protects everyone. That's the point I would make. I went way past my time. I'm sorry, but I appreciate the indulgence, and I yield back the balance of my time.